সরাসরি নজর রাখবো কংগ্রেসের সাংবাদিক বৈঠকের দিকে।
उन्होंने सस्पेंड कर दिया कन्विक्शन मर्डर चार्ज में। इसको साइड करते हैं माननीय न्यायाधीश, अंडरलाइन करते हैं, लेकिन मेरे विरुद्ध लागू करते हैं। ये आपको पारदर्शी लिखित रूप से आम आदमी को समझने वाली गलतियां बता रहा हूं, मैं कोई कानूनी दलील नहीं कर रहा। तीसरा केस साइड किया है रविकांत पाटिल का, अंडरलाइन किया है, वही कहा है शुड ड्रॉ द अटेंशन ऑफ द एपेलेट कोर्ट टू द कॉन्सिक्वेंसेस दैट मे अराइज इफ कन्विक्शन इज नॉट स्टेड। ये इसलिए लिखा जाता है सेंटेंस कि जहां पर कोई आदमी निलंबित हो जाए, सस्पेंड हो जाए असेंबली से या पार्लियामेंट से, तो ये परिणाम आप लाइए सामने, हम सस्पेंड कर देंगे कन्विक्शन। इसको साइड किया गया मेरे विरुद्ध। ये तो मजाकिया गलती होगी और इसको हम उच्च न्यायालय में बिल्कुल सामने रखेंगे। एक चौथा केस श्याम नारायण पांडे साइड किया गया, आपके पन्ने 6 में होना चाहिए अगर आपके पास कॉपी है तो। उसमें लिखा है similar if the convict is involved in crimes which are so outrageous then it would have serious impact on the public perception of the integrity of the institution, then it should not be stayed. क्रिमिनल मानहानि so outrageous, इसको तो टेररिज्म जैसी बात कर रहे हैं या खून खराबे की बात कर रहे हैं। मानहानि का चार्ज है जो अभी मानहानि के लेवल पे है। इस प्रकार के कई ऐसे और उदाहरण हैं जो दिखाता है कि प्राथमिक सिर्फ देखने से भी निर्णय संदिग्ध है, गलत है कानूनी रूप से, जिसका आधार नहीं है। 3 और जगह, एक उसका उदाहरण है पृष्ठ नंबर 10 पे और एक अंत में वापस बार बार इस न्यायालय ने, इनके माननीय न्यायाधीश ने कहा है कि appellant has insulted and humiliated Mr. Modi, the Prime Minister. And then he said, and other 13 crore members of the Modi community. तीनों जगह ये बड़ा स्पष्ट है, मैं कोट कर रहा हूं, मैं अपनी बात नहीं कह रहा, ये बड़ा स्पष्ट है कि उनका पूरा निर्णय इस बात से एक ओवरशैडो हो गया है या ज़्यादा प्रभावित हो गया या दुष्प्रभावित हो गया है कि माननीय मोदी जी डिफेम हुए। लेकिन वो बात भूल गए जनाब कि मोदी जी तो कंप्लेनेंट ही नहीं है, मोदी जी तो कंप्लेनेंट ही नहीं है। हाँ, अगर आप कहते हैं कि हर उनमें से जो 13 करोड़ मोदी से उन्होंने लिखा है उसमें से कोई भी आके ये याचिका डाल सकता है तो वो बात दूसरी है। लेकिन उन्होंने हमेशा कहा है, ये भी पढ़िए दूसरी जगह जहाँ कहा है उन्होंने, पैरा 5 रोमन 5 एट पेज 12, made derogatory remarks against the Honorable Prime Minister Shri Narendra Modi in general public and further compared the persons having Modi surname. So clearly, unfortunately, he is influenced by the high office of the Honorable Prime Minister, forgetting that the Honorable Prime Minister is not the complainant. As a matter of fact, one of the important points is in defamation law that only the person directly affected can maintain. Now it's a moot question of arguments that the other members of the Modi community can and cannot or to what extent can maintain, वो हम आर्ग्यू करेंगे। लेकिन मैं आपको इसका एक स्ट्रक्चर बता रहा हूँ इस निर्णय का। पहले 10 निर्णय साइड करना, उनके गलत पोर्शंस पर रिलाय करना, ये सजेस्ट करना कि हमने कॉन्सिक्वेंसेस आर्ग्यू नहीं किए, ये नहीं देखना कि वो सब उदाहरण ऐसे केसेस के हैं जो इससे बहुत ज़्यादा सीरियस थे और हमारे डेफेमेशन केस में अप्लाई करना। जो 202 जुरिस्डिक्शन की बात आपको याद है मैंने पहले की थी कि अगर कोलार में ये चीज़ हुई है और गुजरात पहुंच जाए कोई आदमी याचिका लेके, तो 202 प्रावधान में आपको पहले प्राथमिक रूप से थ्रेशोल्ड में शुरुआत में ये देखना पड़ता है कि क्या वहाँ पर अधिकार क्षेत्र यानी जुरिस्डिक्शन है कि नहीं। उस पर पूरा एक सेक्शन लिखा है, लेकिन ये नहीं कहा कि भाई मैजिस्ट्रेट का ऑर्डर जो हमने चुनौती दी है सेशंस कोर्ट में, उन्होंने कहाँ डील किया इसके साथ या उनका इसके साथ डील करना सही है या गलत है, ये कहीं नहीं बता पाए हैं। ये पूरा 3-4 पन्नों पे उन्होंने डील किया है, यानी सेशंस कोर्ट ने, माननीय न्यायाधीश ने, लेकिन ये नहीं बता पाए कि किस प्रकार से ये जस्टिफाई होता है कि कोलार से जो गुजरात की यात्रा है उसको उन्होंने 202 को अप्लाई करे, लागू किए बिना कैसे निर्णित किया। अंत में मैं जो पैरा 12 है उसके अंत का पोर्शन पढ़ देता हूँ, अपनी बात खत्म करता हूँ हिंदी में। Based on the above discussion, I hold that the learned counsel for the appellant has failed in demonstrating that by not staying the conviction and denying an opportunity to contest the election on account of disqualification, an irreversible and irrevocable damage is likely to be caused. आप ये बताएं मुझे, मैं जानना चाहूँगा, मैं एजुकेट होना चाहूँगा कि किसी भी एमपी एमएलए इससे ज़्यादा क्या बता सकता है कि मेरे जो दिन निकल गए पार्लियामेंट के, संसद के, उनको आप वापस नहीं दे सकते. इर्रिवर्सिबल का मतलब क्या होता है? इर्रिवोकेबल का मतलब क्या होता है? और क्या दिखा सकता है कोई दुनिया में ऐसा व्यक्ति नहीं है जो इन्होंने जो लिखा है यहाँ पर, बाय नॉट स्टेइंग द कन्विक्शन एंड डिनाइंग एन अपॉर्चुनिटी, इर्रिवोकेबल एंड इर्रिवर्सिबल डैमेज इज लाइकली टू बी कॉज्ड. दैट इज द होल केस ऑफ राहुल गांधी फॉर स्टे ऑफ कन्विक्शन. बाद में आप कन्विक्ट करिए ना, फाइनल में हियरिंग में कन्विक्ट करिए, लेकिन जब तक ये लंबित है तब तक स्टे करें. इससे ज़्यादा क्या ज़्यादा प्रभावशाली कारण हो सकता है, जिसको 3 सेंटेंसेस 6 लाइन में 12 नंबर पैरा में एक डिस्मिस कर दिया है. ये सब, इसके अलावा बहुत सारे और गलतियां हैं जिनको चुनौती बहुत जल्द से जल्द दी जाएगी. फ्रेंड्स, आई विल बी वेरी ब्रीफ. यू हर्ड मी इन हिंदी. द पॉइंट इज सिंपल इन दैट a most unfortunate and unsustainable legal decision of the magistrate has been upheld in a even more unsustainable and erroneous judgment of the Sessions Court given today. The conviction has been upheld contrary to all basic and elementary principles of law, some of which I will briefly mention. But before that, let me assure you that the judgment will be challenged in accordance with law in the very near future. I am not required to give deadlines and dates. It will be challenged in the Honorable High Court. We are confident that superior courts with constitutional power of judicial review, namely the High Court and the Supreme Court, have the power and will set right these legal errors found in these 2 judgments. We are clear that the judgment is devoid of valid, sustainable legal reasoning. The 1 sentence, 1 line remark of Rahul Gandhi in a 2.5 odd page speech has been from inception distorted completely out of recognition to serve the narrow ends of motivated complainants. That has been hardly interpreted in the Sessions Court judgment, and what little has been said is a complete distortion, legally erroneous. The BJP's speed and zeal to act after the original magistrate order depicts their lightning speed when they are motivated by political animosity, from house taking to electricity connection, disconnection to notices, etc., etc. Their completely misleading and misplaced statements about the OBC community have backfired on them, and the whole community and the whole of India now sees the BJP as misutilizing and encashing the entire OBC community for narrow, cheap political gains. Friends, the voice of Rahul Gandhi is not to be silenced in the manner that the BJP thinks it can do. The BJP has been, in a sense, from Mr. Modi downwards to the government, to the ruling party, captured in a fear psychosis, if I may say so. They have unleashed lakhs of trolls and trollers against Rahul Gandhi. They have the remarkable, unprecedented principle that unless you apologize, we will not allow you to speak in Parliament. They have the even more unprecedented principle of the ruling party disrupting Parliament. They sometimes threaten you with privilege notices, sometimes with suspension, but they do not know the stuff Rahul Gandhi is made of. They do not know the resilience of the Congress. His voice will not be silenced because he speaks to the court of the people first and foremost. He doesn't speak anything which is remotely defamatory in this case, but he will continue to speak fearlessly in the court of the people. And clearly these pressure tactics, from defamation to privileges to not speaking in Parliament to suspension, etc., etc., are intended to silence his strong, fearless voice on issues of governance, rather misgovernance, on issues of corruption, on issues of Adani Gate, etc., which my colleague has been raising continuously for several months. Friends, may I end, without wanting to sound technical, with a few examples which ex facie, on the face of it, not meaning to talk to a legal audience, to the whole world shows how unsustainable the judgment which has come today is. The first 7-8 pages are only quotations from judgments, Supreme Court judgments mostly, underlined by the learned judge. The amazing part is that these are inapposite judgments, selectively underlined, in respect of either offences which are nothing to do or similar to offences in my case, or actually directly supporting my stand. They are underlined and used to dismiss my appeal, whereas a bare reading of those precedents, judicial precedent, shows that they are entirely in the favour of the point I am making. I'll give you a few examples. A case is cited called Sareen's case, where the quote-unquote para is, if so, and the para underlined by the judge, to say why suspension of conviction should happen in the rarest case. When? He underlines this portion. If so, the legal position can be laid down that when conviction is on a corruption charge against a public servant, the appellate court or the revisional court should not suspend the order of conviction. I am surprised that the learned judge did not find out that we are talking of criminal defamation, not a corruption charge, till the date of the judgment today. The next case cited is Navjot Singh Sidhu, which is the para is, but the person seeking stay of conviction should specifically draw the attention of the appellate court to the consequences that may arise if the conviction is not stayed. What did Sidhu do, sir? This is the portion underlined by you. Sidhu A was facing an under trial and partly convicted for a manslaughter charge, /murder charge, being asked to be converted to a murder charge. Murder. He was given a suspension of conviction. And what are the consequences he cited? He cited my MPship will be suspended. I'll be disqualified. What is Rahul Gandhi citing? Is it because his name is Rahul Gandhi? Why this difference in approach? Then the case cited is Ravikant Patil, same sentence, should draw the attention of the appellate court to the consequences that may arise if the conviction is not stayed. What other major or bigger consequence can an MP or MLA draw the attention of the appellate court to than the fact that he'll be disqualified? There is nothing else available or possible, but the learned judge underlines this and suggests as if there should have been some extra consequence which he should have told before I can suspend the conviction. Another case cited is Shyam Narayan Pandey, where the para underlined by the learned judges. Similar is the case with offences involving moral turpitude if the convict is involved in crimes which are so outrageous that it will shock the conscience, serious impact on public perception if the conviction is stayed, etc., etc. Does this fall in that category? I have got 6 or 7 such examples. I am not repeating them. The second part of the judgment in 3 paras repeatedly mentions that it is an outrageous defamation because Honorable Prime Minister Modi has been defamed, and then adds, along with that 13 crore members of the Modi community. Now the second part will be contested in appeal. That's a false, distorted, wrong interpretation. But the first part is clearly actuated by excessive reliance on the alleged defamation of a sitting Honorable Prime Minister, a very high exalted office. It's repeated 3 times by the learned judge, but forgetting that the Honorable Prime Minister is not the complainant. In defamation law, a condition precedent is that the aggrieved party must be the complainant. Here, the second issue, which will be debated, is whether any member of the community is equally aggrieved. Let's forget that. But certainly the judgment proceeds 3 places with an underlining of the fact that it's the Prime Minister who's defamed. Well, sorry, sir, the Prime Minister never complained, he never filed a petition. Lastly, the very last para, again, if I may say so, shows complete lack of application of mind and therefore a erroneous and a fallacious judgment. It's a repetition of the same error where in the last para 12 the learned judge says, The appellant, that is Rahul Gandhi, has failed in demonstrating that by not staying the conviction and denying an opportunity to contest the election on account of disqualification,